It's a common misconception that after 12 months, de facto partners gain some sort of right to a property adjustment. In contrast, the minimum time period requirement is actually 2 years, and there is no automatic entitlement to property adjustment. In fact, the court treats the situation very similarly to married couples, and the same basic rules apply as for any separation or divorce. Under the Family Law Act, a couple, whether same sex or different sex, is in a de facto relationship if they are not married to each other, are not related by family, and have a relationship as a couple living together on a genuine domestic basis. The Act provides that the de facto relationships can exist even where one of the parties is legally married to someone else or in a de facto relationship with someone else. The court treats disputes over children and property the same way as for married couples and will take into account how long you have been together, the nature and extent of your common residence and whether there is a sexual relationship between the parties. Your financial involvement may also be considered, the ownership of your property, the degree of mutual commitment to a shared life, whether the relationship is registered under estate law, the care and support of children, the reputation and public aspects of your relationship. In order to apply for a de facto property adjustment or maintenance orders, you must either have been in a de facto relationship at least 2 years, have a child between you, had one party make substantial contributions such that it would be seriously unjust for the person if the Act did not apply, or have been in a registered relationship. It's important to note the timeframes also. A party to a de facto relationship may only bring an application for a property settlement or maintenance order under the Family Law Act within 2 years of the relationship ending. After this time, both parties and the court's consent will be required.